There are a couple witnesses. Well, actually, Mr. Secretary, call the roll.
Oh, she's not here yet.
Oh, if I couldn't see it on my peripheral. All right, well, we're going to start in the subcommittee. I know we have a witness that needs to get out of here, so we're going to do things a little bit out of order, starting with Senate Bill 1531, then going to Representative Overcast 1644, and then jumping back to the last one, the DNA bill, on Senate Bill 1458. So with that, I'm going to hand the gavel over to Senator Schnelting, and we're going to start with Senate Bill 1531.
Thank you, Mr. Chair. Just begin when you're ready.
Thank you, members of the committee. For the record, Senator Schroer, District 2 in St. Charles County, presenting the substitute. I'm going to be working off the substitute today that should have been in your inboxes yesterday on Senate Committee substitute for Senate Bill 1531. Over the years, we've had several different approaches to fixing our family law system. I think all of us who have either spent time as attorneys or have had individuals who have been in our family law system know it's very convoluted and it's very gray. There's a lot of gray areas. So we're trying to, over the past several years, fill in some of those gaps when it comes to child custody issues. This substitute, and it's continuing to be a work in order, as I'm working with all different parties to make this better and make it fair for all individuals and the children involved. What this does is adds to the list that's out there currently on the 8 factors that judges must consider when determining child custody. It's going to add the child's need for stability, the continuity of care, consistent routine, as well as the capacity of each parent to provide a safe, stable, and developmentally appropriate environment. We make some minor tweaks to motions to modify, but we are including something new which really hasn't been considered before or laid out, and that's children with disabilities or special needs. So in the case of a child with special needs or disabilities, the change in circumstance is something that the court can consider in providing grounds for a motion to modify the existing custody order where one parent's neglect or harm or alleged neglect or harm is requiring the change in the current situation. Lastly, the act that we have in the substitute modifies the provisions of law relating to the appointment of guardian ad litems, requiring them to take initial steps on reviewing medical, educational, and therapeutic records, and also consulting with treating professionals, especially in cases where the child is one with disabilities or special needs. I know we have a couple experts here that we've been working with to kind of go over what we're trying to do. So with that, I'll be open to taking any questions, or if you'd like to call the roll.
Call the roll.
Senators Schroer,
Here.
Gregory 15, Brown 26, Berger, here. May, Roberts, here. Schnelting.
Here.
You have a quorum.
All right, quorum being established, we'll go ahead and continue. Let's go ahead and begin. Any questions for the bill sponsor? Seeing none, thank you very much, Senator. We'll go ahead and rotate those here to testify in favor. Go ahead and come on forward. Make sure you have your witness form filled out, and just begin when you're ready. I'll turn this.
I will fill my witness form out before I leave. Good morning, Mr. Chairman, members of the committee. First, I'll start by thanking Senator Schroer for putting this bill first on the docket. I very much appreciate your working with my schedule this morning. My name is Greta Bax. I am an attorney with Stinson. I am here to testify in support of the Senate Committee substitute for Senate Bill 1531 on behalf of my client, Children's Advocacy Coalition. We believe this legislation represents an important opportunity to begin the discussion, as Senator Schroer outlined, about updating Missouri's child custody laws to appropriately account for the unique child custody situations and issues faced by families who have children with special needs. So we thank Senator Schroer for introducing this bill, And our coalition looks forward to working with not only the Senator Schroer, but the members of this committee and all other interested parties to make sure that we come up with a nice product that protects Missouri families and, most importantly, Missouri's children. Our coalition supports this bill for three chief reasons that the senator already appropriately set forth, so I'll just sort of highlight the specifics. Senate Bill 1531 offers a starting point for Missouri to start addressing the specific gaps that exist in families, in our custody laws that don't appropriately account for the specific circumstances and unique challenges that families face when they have a child with special needs. This is particularly prevalent if a child is nonverbal and can't communicate about what is happening with one parent or the other. And this is particularly prevalent or pronounced if a child who may be nonverbal or may suffer from other challenges or have other needs is experiencing abuse or neglect that doesn't manifest itself physically. So we need to make sure that there are additional protections and parameters in place to take care of those children as well. Second, the current statutory framework offers a lot of procedural tools for families to take emergency steps when the child is in immediate danger, where there is physical abuse, and that's very obvious. We need to have a more open-eyed approach to evaluating instances of abuse and giving the court additional factors to evaluate beyond simply one of the most troubling factors that exists currently on the best interest of the child standard is the expressed point of view of the child. If a child can't express his or her specific point of view or his or her interests, that becomes problematic. So we need to broaden that list to give courts additional tools to address those needs that families and children may have. Finally, I think this offers an opportunity to evaluate, and this is part of a broader discussion, Missouri's current best interest of the child standard that defaults to having the child have an equal relationship with both parents. We need to be open-eyed that of course, that in the best case scenario, you have a child that has two equally involved, equally loving, and equally caring parents, but when that is not the case, we need to reshift the best interests of the child standard to be more child-focused rather than defaulting to meeting the needs and interests of the parents. So our coalition largely supports keeping the conversation opening about making sure that we're addressing the needs and interests of the child first. So I thank the committee for its time and for Senator Schroer for introducing this legislation, and I will be happy to entertain any questions.
Thank you very much for your testimony. Any questions for this witness? Seeing none. Thank you very much for being here today.
Thank you.
We'll go ahead and rotate those in opposition to Senate Bill 1531. Anyone here to testify in opposition? All right, we'll right back to in favor. Anyone else to testify in favor of Senate Bill 1531?
How you doing?
Good morning. Go ahead and come forward. Just make sure you have your form filled out, sir, and proceed when you're ready.
I'll fill it out for you. My name is Paul Vega. I do support this bill. I have a nephew that is fully autistic, nonverbal. I do appreciate how you put in there routine, because in his case, if routine is not followed day by day, there is just a complete meltdown. And I don't know if this applies or if there's already something in there like this, but the other parent has issues with drugs. So I didn't know if there's some kind of way that they could do drug testing during the custody thing. I mean, more for drugs specifically, like street drugs, like, meth, heroin, things like that. I don't want to speak against cannabis because I don't think that affects parenting, but those other type of drugs should definitely be taken into account. And I do appreciate you looking after kids with special needs, especially for my nephew. Thank you so much. Appreciate you.
Thank you very much. Any questions for this witness? Thank you very much. Anyone here to testify in opposition? One last chance. Anyone here to testify in favor? Anyone for informational purposes only? That'll conclude the hearing on Senate Bill 1531. I'll go ahead and turn this back over to the Chair. Mr. Chair.
Thank you. Representative, if you want to take the stand, we're going to go into executive session as long as I can get a second. All right, we are now in executive session. I now move that we bring up Senate Bill 1250 and vote it due pass. Do I have a second? Having a second, we are now on Senate Bill 1250. This is the spousal maintenance bill that we've heard the past several years by the Vice Chairman, Representative Gregory. If you want to have any questions, I'm sure he can answer any of them. Seeing none, I now move that we vote due pass Senate Bill 1250 out of committee. Do I have a second? Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 5-0.
By a vote of 5-0, you have voted due pass Senate Bill 1250. I now move that we bring up Senate Bill 1587 by Senator Ben Brown. Do I have a second? Having a second, we are now on Senate Bill 1587. This is adding one judge in Franklin County, the 20th Judicial Circuit. There any questions on this piece of legislation? Seeing none, I now move that we vote due pass Senate Bill 1587 out of committee. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 5-0.
By a vote of 5-0, you voted due pass Senate Bill
1587.
1587 out of committee. I now move that we bring up House Committee Sub for House Bill 2641. Do I have a second? Having a second, we're now on House Committee Sub, House Bill 2641. This is the cannabis or hemp bill by Representative Hinman that was heard last week. There are no changes being made on this. I do think that there are some discussions that there is likely to be a Senate committee or a Senate floor sub, but at this time we're just on the House Committee sub for House Bill 2641 as written and heard last week. Are there any questions? Seeing none, I now move that we vote due pass House Committee sub for House Bill 2641 out of committee. Do I have a second? Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 5-0.
By a vote of 5-0, you voted due pass that bill out of committee. That House Committee sub. All right, going back into, all right, now move that we vote or get out of executive session and go back into public hearings. Do I have a second? Having a second, we are now on House Bill 1644 by Representative Overcast. Please proceed when you're ready.
Yeah, good morning, Mr. Chairman, members of the committee. For the record, I'm Representative Matthew Overcast from District 155. That's Douglas, Ozark, Taney, and Southern Stone counties here in Missouri. So House Bill 1644 at its core is about clarity, fairness, and protecting Missouri small business while preserving worker rights. This bill passed out of our Economic Development Committee in the House at 13-0 and also Rules 9-0. This bill has to do with what is considered the joint employment standard here in Missouri. Just for a little bit of context, so before we get into that, franchising is a major driver of Missouri's economy. We have nearly 17,000 franchise businesses in our state, supporting roughly 18,000 jobs and contributing more than $17 billion to Missouri's GDP. And importantly, these are overwhelmingly locally owned small businesses. Missourians employing Missourians and investing in those communities. Right now, Missouri law does not provide clear, franchise-specific joint employment standards. That lack of clarity provides some real problems. For franchise owners, it increases the risks, raises insurance costs, discourages support from franchisors when they fear being pulled into employment litigation. House Bill 1644 fixes that by establishing a clear rule. A franchisor is not the employee of a franchisee or a franchisee's employees unless the franchisor directly and immediately controls essential employment decisions. That's hiring, firing authority, wage setting, compensation structure, scheduling of hours of work, and supervision and direction of employees' work. This is a balanced approach. The worker protections remain fully intact. Employees still retain every legal claim that they currently have against their actual employer, their franchisee, and against the franchisor that truly exercises that control. So it provides predictability. It protects those locally owned franchise businesses from unfair exposure, encourages franchisors to continue offering resources, compliance training, and operational support, and reduces unnecessary litigation and uncertainty that ultimately costs jobs. Missouri's not alone in trying to do this. 21 other states have already enacted similar laws, including our neighboring Iowa, Arkansas, Kentucky, and Tennessee. So this bill places Missouri in line with the other regional states, mainstream while preserving liability where real employer control actually exists. We want to hold employers responsible, but in this context, generally what I like to use the hotel example, right? And in that situation, a lot of times they're contracting for name and name alone. The actual, we'll just say hotel company A, the independently owned and operated location, they have nothing to do with the hiring decisions, directing those employees. So, we want to correct bad behavior where there's bad behavior, but allowing them to go after Hotel A rather than the independent location isn't going to change that behavior. So this bill really just kind of puts that liability where it needs to be, and also those protections as well. And with that, I'll take any questions.
Thank you, Representative. This bill's been around for quite some time.
Sure has.
I know I've had it. Congressman Onder, when he was in the Senate, has had this. Can you just dive into, for the members who aren't necessarily familiar with this bill, how you would prove direct and immediate control over the hiring, termination, discipline, and direction of the franchisee's employees?
Yeah. So how would you prove that?
Yeah.
Well, there would have to be evidence to suggest that they were actually doing that thing, right? So
Like training manuals,
training,
and things of that nature?
yeah, training manuals, some sort of actually policies that they have to they have to work from this time to that time, really, your employees, need to, there's a lot of potential ways that that could go down.
I know it comes up every year. I know McDonald's. I'm not advocating for McDonald's. I love their work ethic and their presence in the communities. I, usually don't go there for any food, but all of their workers and owners were up here several weeks ago saying that this was an incredibly important piece of legislation, and they were kind of going over some of those pieces of evidence that you can use to prove direct and immediate control, where you're not just contracting for the name and the naming rights, like we've seen with some of the hotels after, I think it was in Minneapolis or Minnesota with the ICE incident. But with that, I'll turn it over to Vice Chair Gregory.
Thank you, Representative. I'm just along those same lines, I guess more of a comment than a question, but it's been my understanding from filing lawsuits and looking at these franchise agreements, which are extensive, long,
Very long,
controlling, very direct on the hiring process, very direct. And of course, if the franchisee doesn't do precisely what the franchisor requires, there are ramifications for that. So here we have it. The franchisee has to do precisely what the franchisor says to do, but oh, by the way, franchisor has nothing to do with the hiring and the firing. I just find that very interesting, and I'm looking forward to thinking through different examples to make sure. The intent is there, I get it, but man, to have to prove all of these, not just one of them, direct and immediate control over hiring and termination and discipline and direction of the franchisee's employees, wow. It just seems to be stonewalling any liability for the franchisor. But again, I'm open to listening to expert comment. So,
and there'll be experts that
Yep.
can answer a lot of specifics on that.
Any further questions? Seeing none, we're going to go to the first witness in support, and you'll be time limited for 5 minutes for the first two witnesses, for and against, and then we're going to go to 3 minutes. And we will be alternating. Please come forward, make sure your witness form is filled out, state your name for the record, and you'll have 5 minutes.
Thank you, Mr. Chair, members of the committee. Michael Henderson on behalf of the American Hotel and Lodging Association. Do have a joint letter signed by the association and the Franchise Association as well that I will leave with my witness form. We're in support of this legislation, and the companion bill filed by the chair for the certainty and clarity that it helps to provide here in the state of Missouri. I think Representative Overcast laid out the bill well, and happy to answer any questions related to the bill.
Any questions? Seeing none.
Thank you.
We're going to move to those opposed to House Bill 1644. Seeing none. Any for informational purposes? Seeing none, we're going back to those in favor of House Bill 1644. Please come forward.
Good morning, Mr. Chair, members of the committee. Jared Hankinson, representing the Missouri Chamber of Commerce and Industry. Appreciate the time today. I had nothing to add on top of what Representative Overcast offered. I think he detailed the bill well. We'll just emphasize that for Missouri employers that are working within this franchisee-franchisor model, this is an important protection that we've heard time and time again, and happy to take any questions.
Any questions? Seeing none.
Thank you very
for your
much.
Time today. Any further witnesses in support of House Bill 1644? Seeing none. Any for opposition? Seeing none. Any for informational? Seeing none. That was a quick hearing on House Bill 1644, and that will conclude the public hearing. Now moving to the last bill, I'm going to have the Vice Chairman take over the reins on Senate Bill 1458.
Mr. Chairman, you may proceed when you're ready.
Thank you, Mr. Chair, members of the committee. For the record, State Senator Nick Schroer on Senate Bill 1458. This one is very detailed, and it's very important. So let me just dive in. I know we've got several experts here today, but Senate Bill 1458 is going to give another tool to our law enforcement that a majority of our states already have. It's the collection of DNA at the time of felony arrest. And I know a lot of us who are liberty-minded and conservatarians at heart, we're probably thinking, well, wait a second, this is an egregious invasion of privacy. Well, we've already had this detail ironed out by the United States Supreme Court in Maryland versus King, stating that a simple collection of the DNA with a cheek swab during a lawful arrest for serious felonies is a reasonable booking procedure, much like fingerprinting or photographing. So now in Missouri, we are kind of handcuffed on our ability to dive into some of these cold cases and use the combined DNA index system, the CODIS database, to help us solve a lot of these existing crimes. What this bill does before you today is gets us in line with 30 plus other states that are allowing for the collection of DNA at the time of arrest. And DNA doesn't just solve crimes after they occur, it also helps prevent future crimes. Research is showing that requiring individuals to submit to a DNA sample at the time of arrest significantly reduces the likelihood that they will commit other serious offenses. This bill's about protecting victims as well, especially survivors of sexual assault. During our time, Mr. Chair, in the Missouri House, I know the legislature did a lot of work on DNA samplings and cold cases, working with now Senator Eric Schmidt when he was Attorney General. And we see with these kits, Missouri has made a lot of progress in testing these backlog rape kits. But those kits are only useful if there are DNA profiles available to match them against. Expanding DNA collection increases the likelihood that those matches can occur and that perpetrators can be essentially brought to justice. This is also a cost-effective investment for the state of Missouri. Expanding Missouri's program is estimated to cost about $1.37 million per year, but research is showing that every DNA profile entered into the system saves taxpayers tens of thousands of dollars by preventing future crime. Importantly, this bill, like I stated before, is respecting civil liberties. Pursuant to the Maryland versus King case, this legislation is narrowly tailored to continue in that precedent that the Missouri or the United States Supreme Court had set out. The DNA profiles used by law enforcement do not reveal any sort of health information whatsoever, ancestry, genetic information. They're simply numerical identifiers used to match someone to evidence at a crime scene. Missouri law also provides clear protections requiring the expungement of DNA records if charges are dismissed or if a person is acquitted. And with that, I would be more than happy to answer any questions or turn it over to the experts behind me who took time out of their day to be here.
Excellent. Questions for the senator? Senator Berg.
Are DNA samples taken now at all on any crimes, or at what point?
Well, and that's where there's a little confusion with our law. They are taken in some instances, and depending on the officers that you talk to, depending on the departments that you talk to, they're taken for some serious crimes, but not all. And this kind of gets clarity and consistency across all departments in the state.
So that's kind of at discretion of the officer or the arresting officer or the department, basically?
Somewhat. There are some laws that are laid out within our statutes, but it's kind of sporadic. We've seen, several bills over the years where we're doing a lot of cleanup language. This is one that, when in talking to law enforcement and talking to the experts that are here, we discovered that there are some crimes that require you to take DNA, and then there are other crimes that probably should, very serious crimes that should, if you're going with that legislative intent of the past legislatures that enacted those provisions. So, yeah, I think it's very confusing for some officers who don't know, okay, is this a crime that I can take DNA or not? And by having this legislation moving forward, it kind of provides that consistency.
Okay, thank you.
Any further questions for the senator? Seeing none. First witness in favor to testify on Senate Bill 1458. You both may proceed when you're ready.
Thank you so much. Good morning, members of the committee. I'm honored to discuss the important issue of expanding. I'm John Roman. I work at NOIC at the University of Chicago. And I'm honored to discuss the important issue of expanding eligibility for inclusion in Missouri's DNA index system to solve more crimes, hold more offenders accountable, improve public safety, and reduce the risk of wrongful conviction. Despite substantial growth in CODIS, the database's effectiveness as an investigative tool as a deterrent has remained limited. Specifically, outside the most serious crimes, CODIS is used infrequently to aid criminal investigations. In particular, DNA is rarely used as an investigative tool in high-volume crimes such as residential burglary. Even in serious violent crimes, DNA is often used as leverage in plea negotiations after an arrest, rather than as a means to identify otherwise unknown criminal offenders. One major reason CODIS is not used more often to solve crimes is that eligibility is largely limited to people convicted of the most serious offenses. Because these individuals typically receive long sentences, their DNA profiles are added infrequently, keeping the CODIS database relatively small. Expanding the database would improve the effectiveness of DNA as an investigative tool. CODIS expansion can reduce crime through two main mechanisms: supporting criminal investigations and promoting deterrence, preventing crime, as we heard. It directly supports criminal investigations by giving investigators a far more accurate and reliable tool for identifying unknown suspects compared to traditional methods like witnesses and fingerprints. Research underscores the value of this capability. In my own work, when I was at the Urban Institute, conducted in partnership with the U.S. Department of Justice, we found that collecting and testing biological evidence from residential burglary crime scenes led to the identification of a perpetrator more than 2.5 times as often compared to business as usual criminal investigation, and doubled the likelihood of an arrest. Developing DNA evidence was 3 times more effective at identifying a suspect than fingerprint collection. The cost of DNA evidence collection, testing, and the added cost of finding and arresting a DNA-identified suspect are modest, about $3,500 per arrest to identify an otherwise unknown offender. And this is really important, gets lost a lot. Criminal histories for offenders arrested just for residential burglary through DNA identification show a pattern of serious chronic offending. The average person arrested after a DNA-aided investigation in a residential burglary has 3 prior felony convictions and almost 6 prior felony arrests. And these aren't just for burglary. These are for serious person crimes, shootings, assaults, robberies, weapons, etc. Expanded use of DNA evidence collection and testing reduces the likelihood that any person is wrongfully arrested and convicted of a crime they did not commit. CODIS-aided investigations have many advantages over traditional investigation, including advantages over fingerprint comparisons. Specifically, the probability of a match between DNA from a crime scene and a suspect's DNA can be precisely estimated. It can be quantified. By contrast, there is no objective estimate for the probability that eyewitness testimony or fingerprint or other biometrics match. There's no way to estimate the error around that match. As a result, DNA both reduces the likelihood of wrongful conviction and increases the likelihood of apprehending the true offender. And critically, adding arrestees to CODIS moves the discovery of wrongful detention much earlier in the process, from the conviction stage to the arrest stage, making it easier to correct. The available evidence supports expanding eligibility criteria for inclusion in CODIS to improve public safety, reduce disparities, and facilitate more just outcomes. Thank you very much.
Any testimony from you?
Mr. Chair, members of the committee, I'm Ashley Spence, the founder of DNA Justice Project. I am here in strong support of SB 1458. In the middle of the night, I was violently awoken to a pillow suffocating my face and a stranger tearing my clothes off from the waist down. "Wake up, Ashley, this is a nightmare," I said, but quickly I realized this is not a nightmare. I'm gonna have to fight for my life. I was 19 years old, about to start my sophomore year at Arizona State. While I was asleep in my bed, an intruder came into my apartment, into my bed, and began to rape, beat, and nearly killed me. I was forced to endure his torture for hours. And before he left, he said, "Do not tell anybody, because if you do, I will be watching you just like I was before, and I will kill you." He got away. I never saw his face. I worked day and night with detectives, but the fear paralyzed me. I dropped out of school. I moved to Newport Beach, California, and eventually back home to my state of Texas. It was there 7 years later I got the call, a DNA match. And I moved to Newport to escape this man, but in reality I moved to the very city that he lived unknowingly. He was apprehended 1 block from where I lived in Newport Beach on 41st Street. I was on 40th, trying to break into a home where 3 young girls lived. An officer saw him. They got into an altercation. He ended up resisting the officer's arrest. That is what he was swabbed on. So California is one of the states that collects for every single felony arrest. They took him to the booking station. They took his fingerprints, his photographs, a minimally invasive cheek swab. They uploaded it into CODIS, and it matched mine and multiple others. He was a serial predator. He had a wife and a son and a shed behind his home full of women's underwear and ID cards from all over the world. A lengthy criminal history, DNA never taken. So he was not getting caught for the violent rapes. He was getting caught for lower level felonies along the way. Now, we waited on trial for 5 years for the Supreme Court ruling that the chairman brought up, Maryland versus King, 2013. They said taking DNA cheek swab for a qualifying arrest, a serious offense, is a reasonable part of the booking procedure. In fact, it's just like fingerprinting, but it's even more accurate. So because of that, we went to trial. It was used as the investigative lead, and he is now in prison for 137.5 years. I am so fortunate to have this justice, but sadly, as we know, so many victims do not. And as the law stands in Missouri today, had my perpetrator been arrested here, he would still be free raping and terrorizing his victims because he would have not swapped his cheek for that. So in California is one of the states that the Department of Justice study found from a sample of 3,778 felony arrestees, only 8% of hits went to murder, rape, and robbery that came from violent crime. So that means 92% of the hits to that came from lower level felony arrestees. In Texas, my home state, we expanded to collect for every single felony arrest. When we did that in 1 year, Texas DPS just announced, we solved 1,005 cold cases. New Mexico, when they expanded for all felonies, they had an 83% match rate increase in the database. So we know that this works, and CODIS is very secure and private. It is not your entire DNA. It wouldn't say that I'm Lebanese, that I'm predisposed to any genetic diseases. It doesn't even have a name in the system. It's just a series of numbers out of 3 billion markers that make us whole and human. Only 20 were picked by genetic scientists, okay? So it's a great system that is not accessible by third parties. If you're found not guilty, it's a federal law that your DNA has to be able to be expunged and completely destroyed. The Office of the Inspector General, they do annual audits as well as random audits on the lab, and there are heavy fines and jail time if that's not followed through with. And in Colorado, the most prolific serial rapist of young girls, for 4 years he was on the loose, never was caught. They expanded to collect for all felony arrests. A year later, a man was arrested on felony forgery. They swabbed his cheek, they put it into CODIS, and guess what? It matched the rape of the young girls. Alternatively, in New Mexico, equally as important, a man was innocently and wrongfully accused of the rape and murder of an 11-year-old Victoria Sandoval. Now, he was not mentally fit to even go to trial for, I think, 2 years. Finally, they put him on trial. They said he admitted to doing it, so they convicted him. Meanwhile, New Mexico passed this law to collect for all felony arrests. The real perpetrator, Israel Diaz, was swabbed on a felony charge, unrelated. They uploaded it into CODIS, and it matched the rape of the young girl. So we are catching true perpetrators, and we are preventing them from wrongful convictions. And finally, as we briefly touched on, we save lives and we save millions. Jennifer Doliak's 2017 economic study found that for every cheek swab that we enter into CODIS, we prevent 0.57 serious offenses, which saves the society $27,000 in crime costs. So it's one of the most fiscally responsible public policies that we can make. And so to conclude, for 7 years, I can tell you all, while my rapist was free, I had to battle my demons. But the most haunting thing was I would hear the screams of his victims in my head. It terrorized me. I knew he was out there. As the law stands in Missouri today, he would still be free, but we have the power to come together to change that, and I just want to say I honor and recognize all of the hard work that you all do for justice in Missouri. You do incredible work. This will only continue to build upon your successes, and I'm a mother, and I just can't think of, the daughters of Missouri that we could actually protect if we make this a law here. So I thank you so much for your time. Thank you, Chairman, for bringing this, and if you have any questions, I would be honored to answer them to the best of my ability.
Thank you, Ashley, for sharing your story. And in my opinion, it makes it a no-brainer. Questions for the witness? Seeing none. Thank you both so much for being here.
Thank you all so much. I really appreciate it.
Next witness in favor of Senate Bill 1458.
Good morning, Mr. Chairman, members of the committee. My name is Jason Olin. I'm the Senior Government Affairs Manager for Criminal Justice at the Niskanen Center, a nonpartisan think tank based in Washington, D.C. Our work in criminal justice policy is grounded in the belief that minimizing crime is necessary to a free and prosperous society, and that policies aimed at crime reduction should be rooted in the best available evidence. By requiring DNA collection at the point of arrest for all felonies, SB 1458 will reduce crime in Missouri in 2 key ways. First, law enforcement will catch more criminals who have avoided punishment for prior crimes and could still be victimizing innocent Missourians today. Second, potential repeat offenders who know their DNA is already in the state's database will have a powerful incentive to think twice before committing additional crimes here in the state. Research confirms both of these claims. The best study on this issue, which was done by Dr. Jennifer Doliak, found that felony arrest DNA collection reduces murders by 3.2%, sexual assault by 6.6%, aggravated assaults by 2.9%, and vehicle thefts by 5.4%. The study also found a 17% reduction in 5-year recidivism rates for serious violent offenders and a 6% reduction for serious property offenders following the expansion of DNA collection laws. 19 other states in the country already mandate DNA collection at arrest for all felonies. This bill would bring Missouri in line with its neighbors, including Arkansas, Oklahoma, and Kansas, who have all already adopted this common sense policy. I also want to note that there's broad support for this policy amongst Missouri voters. A 2026 poll shows that more than 80% of Missourians support collecting DNA at the point of arrest for all felonies. And I also just want to note that we worked closely with the Missouri Highway Patrol when we were developing this legislation. We know that the most important factor in crime deterrence is improving the likelihood that a criminal is caught, and SB 1458 reflects that fact. This legislation is supported by strong evidence and will make every single one of your constituents safer. The Niskanen Center strongly encourages the committee to report this legislation favorably. Thank you for your time, and I look forward to any questions you may have.
Questions for the witness? Seeing none, thank you so much for being here. Next witness in favor of Senate Bill 1458. Arnie, I'm now limiting testimony to 10 seconds. You may proceed when you're ready.
I thought it was 5 seconds. Good morning, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. I highly support SB 1458. This is a no-brainer. Entering the database of fingerprints and DNA will solve crimes with major felonies. It states to criminals across our state in all four corners and zigzag in all of our 115 counties, including the city of St. Louis, that we mean business. And we are not going to condone or put up with crime or bad actors. We are going to be hard on crime, and we are going to make sure that if you don't think and use your brain before you commit a crime in our state, we're going to make sure that you're entered into the database to solve other crimes and other issues. If you do the crime, you're going to go into the database. That's a choice that you made. It's unfortunate. You should never put yourself in that position. But if you do it, guess what? You're going to be in there forever. And if you do another crime, the law enforcement is going to find you. Prosecutors are going to prosecute you. And the courts are probably going to send you to the state penitentiary. For those reasons, I highly support SB 1458. Thank you, Mr. Vice Chairman.
Thank you. Questions for the witness? Seeing none, thanks so much for being here. Next witness in favor, Senate Bill 1458. Seeing none. Next witness in opposition to Senate Bill 1458. Seeing none, any witnesses to testify for informational purposes only? Seeing none, this concludes the hearing on Senate Bill 1458. I move that we adjourn. Do I have a second? Second, we are adjourned.